Islamic jurisprudence functions as a structured, immutable operating system running beneath the surface of modern religious practice. While individual beliefs vary, the legal architecture governing the religion, traditional Sharia, remains a fixed, documented code. In Islamic theology, the Quran is the direct, unalterable word of Allah. It serves as the primary source of the law. Because the Quran is often brief in its specific commands, the system relies on a second tier of authority to execute those laws, the Sunnah. This is the practical, lived precedent of the Prophet Muhammad. Muhammad's actions and commands were recorded in texts called hadiths. The most rigorously authenticated of these are the Sahih collections, massive historical records used to verify exactly how the Prophet behaved. To turn these texts into actionable law, classical scholars synthesize them through exegesis, known as tafsir, and jurisprudence, known as fiqh. They bound the Quranic commands and prophetic actions together into concrete legal rulings. Understanding traditional Islamic doctrine requires a structural analysis of how these tiers of text interact to produce specific legal endpoints. This pipeline acts as a chain of custody for the law, moving from divine injunction down to human application. A doctrine is legally binding in traditional Sharia when a Quranic principle is confirmed by a prophetic action and codified by classical scholars. To observe how this engine functions, we will pass two controversial subjects through this derivation pipeline. First, we will examine the legal framework governing prepubescent marriage and the age of consent. Second, we will trace the directives governing warfare and the civil rights of non-Muslims. Practices that pass through all three nodes are technically verified as foundational Islamic jurisprudence rather than cultural anomalies. We begin the first derivation at the highest level of authority, the Quran. Surah 65, verse 4, discusses the required waiting period for women undergoing divorce. For those who have passed the age of menstruation, it mandates a 3-month wait. The verse applies that same waiting period to another category, those who have not yet menstruated. By prescribing a divorce protocol for females who have not yet reached puberty, the text presupposes a scenario where a prepubescent female is already married and subject to divorce procedures. This verse provides the structural legal opening for child marriage within the Quranic text. The Quran establishes the theoretical baseline allowing for the marriage of biologically immature girls. We move to the second node of the pipeline to find the prophetic application of this Quranic baseline. Multiple Sahih hadiths, including those found in Bukhari and An-Nasa'i, document the Prophet Muhammad's marriage to Aisha. These texts record a marriage contract signed when Aisha was 6, with the marriage consummated when she reached the age of 9. This historical precedent moves to the third node of the pipeline, scholarly exegesis. Classical scholars such as Ibn Kathir and Al-Tabari synthesized Quran 65:4 with the historical Aisha precedent. Their resulting legal ruling states that fathers and guardians possess the irrevocable right to marry off minor daughters at their discretion. This derivation explains why classical Sharia does not recognize a fixed biological age of consent. This conclusion follows the internal logic of the three-tier derivation process. We reset the pipeline for the second case study, the legal status and treatment of non-believers. The Quranic baseline for this subject is found in Surah 9, specifically verses 5 and 29. Verse 5 directs Muslims to capture or kill polytheists wherever they are found until they convert to Islam. Verse 29 directs Muslims to fight Jews and Christians until they submit to Islamic authority and pay the jizya tax. These directives split the world into two territories, the House of Islam and the House of War. These verses frame warfare as a structural mandate for theological expansion. The Quran provides the mandate for a bifurcated legal reality based on religious belief. We trace these mandates into the Sunnah to see their impact on domestic criminal law. Qisas, or equal retaliation, is the standard penalty for murder between two Muslims. Bukhari 6915 states, "The judgment that no Muslim should be killed in Qisas for killing a kafir." Scholars use this asymmetry to deny equal protection. The logic of warfare and subjugation abroad mirrors the domestic civic code. The technical term kafir describes the category of person to whom these asymmetric laws apply. The structural subjugation of non-Muslims is a codified legal necessity derived from the highest Islamic authorities. The derivation pipeline reveals two specific endpoints: codified prepubescent consent, and legal asymmetry for non-believers. These results emerge from the literal and historical synthesis of the Quran and the Sahih Hadith. This technical Sharia operating system stands in contrast to the universal principles of human rights and equality found in modern secular law. These two systems operate on different foundational premises regarding human value and consent. Recognizing this difference is essential for a rigorous study of comparative law and theology. Traditional Islamic jurisprudence remains a self-consistent, rigid framework derived directly from its own textual bedrock.